The New York Times defended itself against a defamation claim from Justin Baldoni and Wayfarer Studios. Same case, same judge, same type of claim. Their attorney fee request was $168,000. Blake Lively just filed her fee request for the same type of claim in the same case. She is asking for $7.5 million, plus another $540,000 in costs. That is 45 times what the New York Times asked for. And the way she got to that number tells you everything about how this woman has operated from the first day she walked into this lawsuit. Here's what you need to understand first. This fee motion is not a legal document. It is a press release with a case number stapled to it. The judge's ruling was specific. Blake gets attorney fees for defending the defamation counterclaim. One claim only, not all 7 causes of action in Baldoni's lawsuit. Not her own lawsuit against Baldoni, which she settled for $0. Not the discovery fights, not the media war, not the 18 months of scorched earth litigation. One single claim. So what does her lawyer, Michael Gottlieb, do? He files a 19-page declaration arguing that the costs cannot be separated. He says the defamation defense was so intertwined with everything else that you cannot pull the thread apart, and therefore Wayfarer should pay for all of it. The judge said you get fees for one claim. Blake's lawyer is arguing that one claim should cover the entire bill. That is not a legal argument. That is a negotiation tactic from someone who has confused a federal courtroom with a real estate closing. And here's the part that should genuinely make your head spin. Because Blake's own argument, the one her lawyers filed under penalty of perjury, actually destroys her own case for fees. So stay with me for a bit. If Blake's lawyers are telling the court that the defamation defense cannot be separated from the rest of the case, then by their own logic, the defamation claim did not generate any additional legal fees. She would have spent the same money whether that claim existed or not. If everything is intertwined and nothing can be pulled apart, then the defamation piece cost her nothing extra, which means the reasonable fee award for that specific claim is $0. Her own argument eats itself. She is asking for $8 million using logic that, if the judge actually follows it, gives her nothing. And if Wayfarer's lawyers are smart, that is exactly what they will argue, because it writes itself. But the fee number was never the real product here. The real product is what happens when every entertainment outlet in America runs the headline. And once you see how Gottlieb structured this filing, you will understand exactly what it was designed to do. Let's look at the receipts, because the filing itself is genuinely something to behold. Gottlieb's firm is asking for $4,544,094. Their co-counsel at Manat is asking for another $2,951,432. Then they added $539,514 in costs, because apparently the legal buffet was not full enough yet. Altogether, they are asking for just over $8 million. And once you start looking at how they got there, the whole thing becomes even more absurd. Gottlieb himself billed 224 hours at an average rate of $2,187 an hour. One associate, Michaela Connolly, billed 620 hours by herself. Across Wilkie alone, 6 named lawyers logged 1,738 hours on a case where, on the defamation side, the main event was a motion to dismiss and some follow-up briefing. Meanwhile, Manat did not even provide an individual hour breakdown. They basically handed over a lump sum, smiled politely, and asked everyone to trust the math. And then there is Gottlieb's declaration, which spends 3 full pages listing his own awards, rankings, and legal industry trophies. Chambers, Law Dragon, Hollywood Reporter Power Lawyer, Forbes Top 200 Lawyers. At some point, it stops reading like a fee declaration and starts reading like LinkedIn put on a suit and walked into federal court. He essentially submitted his resume as a legal exhibit and then asked the court to value his time at $2,795 an hour. At that rate, Gottlieb could bill you for a long lunch, a slow elevator ride, and one thoughtful stare out a conference room window, and somehow you would owe more than most people pay in rent. Oh, and by the way, both Gottlieb and Ezra were kind enough to mention that their June 2026 invoices have not been included yet and will exceed $300,000 combined. So the $8 million is not even the final number. They are actively running the meter while asking the court to make the other side pay for the ride. And the justification for these numbers? The declaration argues that the fees are reasonable because the Wayfarer parties were aggressive. They filed a long complaint. They created a website. They gave press interviews. Brian Friedman was mean on television. Basically, their argument is, our opponents fought hard, which forced us to fight harder, which means they should pay us more. That is not how fee shifting should work. That is how a contractor explains why your kitchen renovation suddenly costs 3 times the estimate, even though half the charges are for people standing around discussing the tile. Now, let me be very clear about what I'm saying here, because I am not inside Blake Lively and Ryan Reynolds' bank account, and I do not have their retainer agreement sitting on my desk with a highlighter and a cup of coffee. This is just my opinion. But I have seen enough invoices in my life to know when something stops looking like a clean bill and starts looking like somebody dragged the entire receipt drawer to the counter, and this filing does not smell normal. Because here is what I actually think is going on. I do not believe Blake and Ryan have been paying these firms in full. Maybe not at all. And if you look at this filing through that lens, everything suddenly makes sense. The inflated number, the refusal to apportion, the kitchen sink approach of throwing every billable hour from the entire case into one motion. These lawyers are not filing just for Blake. In my opinion, they are filing for themselves. This looks like a collection effort dressed up as a fee petition, and the judge is the only person left in the room who might make somebody else write the check. That is why the number is absurd. That is why they are padding it with June invoices that have not even been finalized. They are trying to recoup what their own client may not have paid, and now the Wayfarer parties are supposed to cover the tab. Wayfarer gets 14 days to respond, and their argument practically writes itself. The New York Times asked for $168,000. Blake is asking for 45 times that for the same type of claim, in the same case, before the same judge. Whatever Lyman awards, it will not be $8 million. It will be a fraction. Probably somewhere near what the Times received, maybe a little more for complexity. But by then, the headline will have already done its job. The number will have already been printed. And Blake will have already released a statement calling it a victory for women everywhere. Because that is the move. That has always been the move. Win the headline, lose the substance, and count on nobody reading past the first paragraph. She started this case demanding $300 million. She had 10 of her 13 claims dismissed. She voluntarily dropped 5 of her own. She settled everything for $0. And now she is asking a federal judge to make the other side pay her lawyers $8 million for writing a motion to dismiss that any competent firm could have handled for a fraction of the cost. It worked for 18 months. It is not working anymore. That is the Blake Lively fee motion they do not want you to actually read. If you made it this far, like the video, subscribe if you haven't, and hit the bell so the next filing breakdown finds you. Wayfarer's response will be coming soon, and I will be here when it does.
That's my opinion!